Welcome to Law, Life, and Liberty with Anthony Puopolo.
Welcome to Law, Life, and Liberty with Anthony Puopolo. Anthony is a Massachusetts attorney who helps families navigate divorce, custody disputes, and criminal charges that often overlap. With offices in Lowell and North Andover, he represents clients across Middlesex, Essex, and Suffolk counties in both family and criminal courts. I'm Lisa Mosby, and today we're talking about how text messages, emails, and social media can end up being used as evidence in Massachusetts divorce and custody cases. Welcome, Tony. I'm looking forward to another very informative conversation today.
Thank you so much, Lisa. Good morning.
Tony, when someone is going through a divorce or a custody dispute in Massachusetts, how often do text messages or social media posts end up becoming a part of the case?
Well, I would say in almost every case, my client will bring me text messages and social media. It's not always going to be something that will wind up being evidence at a trial if a trial occurs, but it certainly does give color to arguments, and they'll be mentioned during motion hearings. And it is really almost every single case that comes to me these days. I would say the only real exception would be in the rare occasions where I have divorces with elderly persons. If you grew up in the social media age, odds are when you go to your divorce lawyer, you're going to be bringing those kinds of things to your divorce lawyer to support your claims.
And even in today's society, it continues to surprise me that a lot of people assume their private messages won't really matter in court. In your experience, how often do those communications actually become evidence in a divorce or custody dispute? Does it happen?
It can, depending on who the communications are between and for what purpose those communications are offered. So Massachusetts recognizes a marital communications exclusion. So your messages between you and your spouse are not going to become evidence at your trial because those communications are excluded from an actual trial in Massachusetts. But it is theoretically possible if a lawyer is able to obtain messages between you and someone else in a way that can be used properly under the rules of evidence, that they could come in. So let's say you are caught in a lie about, your involvement in your children's soccer camp, for instance, that you're trying to make it look like you're more involved than you are. Communications between you and the soccer coach that prove that you're lying could ultimately come in at trial. So the general rule of thumb is assume that nothing is private.
Well said. What kinds of messages tend to cause the biggest problems for people once the case reaches court?
I would say anything that's violent or threatening. We all say things in arguments that we regret, but some people can certainly cross a line where it would make a reasonable person fearful. Those can be major problems. In the past few years, Massachusetts has started to recognize what we call coercive control, which is communications which tend to try to alienate a significant other from their friends and family, are financially controlling, things like that. So communications like that are also problematic. I recently had a person who claims it was a joke, but in writing, it's hard to see the context. He told his wife she could get her nails done only if she engaged in certain activities with him later that evening. So that became a major problem because the joke is not able to be seen when you're just looking at a black and white text.
Right. During a difficult breakup or divorce, people often send emotional or angry messages. How can that kind of communication affect issues like custody or parenting time?
So in a divorce situation, the statute that controls says that there is a presumption of equal parenting between the two married spouses. That said, the next statute says if there is a history of domestic violence, then that presumption is kind of out the window, and the court has to look at what's best to protect the abused parent as well as the child. So messages which may rise to a level, now that abuse also includes the definitions of coercive control, such as, alienation, demeaning kind of communications, it does make a court concerned as to whether or not there's an imbalance of power, and whether or not these people are going to be able to co-parent in an effective way, or if one parent should be given sole legal custody. So again, keeping these messages and it's difficult because it's always retrospective. You're always looking at messages that have been sent historically. But the best you can do once the divorce starts is to try to keep it as professional as possible, because these communications can hurt you.
And Tony, beyond text messages, how often do things like Facebook, Instagram, or other social media posts show up as evidence in divorce cases?
So it does depend on the nature of the case and what the allegations are, but it absolutely can be very relevant. Let's use Johnny's soccer camp as an example again. If you are out at dinner with your friends, posting photos of yourself at dinner at the time you're claiming to be at Johnny's soccer game, that's likely going to come in to prove to the judge that you're lying. I've had, situations where one parent is claiming, that the other parent was horrible to them and, violent emotionally, but constantly posting things of them together and smiling and happy with people who would all testify that they personally never saw any kind of negativity between the parties. Things like that can absolutely come in. Same in the converse. If you're posting horrible things to your significant other in a public forum, you're not necessarily going to be able to benefit from the marital communications privilege because you've made it public. So if you're getting into a public argument, that can come in.
And if someone realizes that they sent a message that they regret sending, can deleting that message help their situation, or does it actually make it worse?
It would make it worse. I've had situations, I tell people all the time, especially the ones who come in with restraining orders, who tell me, I just wanted to get rid of all of the messages with this person. I wanted to completely forget about them and put them behind me. I always tell them, and it always bites me, I always say, it's the messages I'm not prepared for that wind up becoming a problem, and they always are. One, you don't know if it was deleted. Only nowadays it's things like iMessage. You're relatively confident that they are deleted on both sides. But what if that person took a screenshot of it before you edited it? You don't know. And if it looks like you're trying to hide things, the judge is going to want to know why. Years ago, I had a complaint for contempt after a divorce, where my client had deleted a bunch of communications between herself and her former husband about the husband being able to have the child on Thanksgiving, because this person didn't want the former husband to have parenting time that day, but didn't want her new husband to know that she was deliberately trying to withhold the child. And that wound up coming out in the contempt hearing because he had screenshots, even though she tried to delete things later. So not only did it become a problem with the judge, it became a problem with her new husband.
And Tony, from a legal standpoint, how do attorneys typically obtain these messages or social media posts during a divorce case?
So it is very difficult. You typically get these from your client, but being able to use them in a trial is very problematic. The rules of evidence can be very strict, and getting them from places like Facebook, there are federal laws that allow Facebook to refuse to provide these documents. I ran into this very recently. I sent a subpoena to Facebook that they refused. We tried to fight it out in court, and I lost. Because the reality is there's a law called the Electronic Storage Communications Act, which allows them to say they are not required to produce the contents of electronic communications to a subpoena. They have to produce it for people like the FBI. So it can be very difficult to get these messages. Typically, I get them through my client, and then it's a question of whether or not I can actually use them consistent with the rules of evidence from there.
So the screenshots and taking pictures of different things is probably the most common. Is that true or not so much?
Yes, I would say the screenshots are the most common way I get these messages. It's just whether or not I can then use them, and whether or not it can get them what we call authenticated. I have to be able to prove to the court that these are real, authentic messages. Typically,
Okay.
that's done by getting them directly from the provider, like a Facebook or an Instagram. But that can be difficult with federal laws. So just because I have them doesn't necessarily then mean I can use them.
I follow you. And then what kinds of communication patterns tend to raise red flags for judges in custody disputes?
A pattern of demeaning your significant other, particularly if, let's say if it's public, if it's someplace where your child will see it, that's going to be a big red flag for a judge. Threatening communications, coercive control. Now that is a big part of divorces since June of 2024, when coercive control became part of the ethos of domestic violence in the Commonwealth of Massachusetts, legally anyway. It's a big thing. We're very much looking at whether or not these communications are intended to isolate a spouse, to cut them off from supports, to box them into a corner where they are not able to be a co-equal parent with the demeaning parent. Those can be very big red flags for a divorce judge.
And Tony, I kind of want to come back to this form of communication with texting and social media. How often does your investigation reach out to people outside of the marriage, maybe friends who you've engaged with about what's going on? Do other people become part of this as far as creating and not creating, but offering evidence?
It absolutely can, particularly if they're your words. So if you are reaching out to, say, your significant other's sister, I had a situation, I have one now, where my client reached out to his significant other's mother about arguments between them. And those communications wound up going to my client's significant other. And they can be used against you because they're your statements. So they're what we call an admission. So they're an exception to the normal hearsay rule. So the general rule of thumb you should always operate under is that assume anything you put in writing can always be used against you later. If you live by that rule of thumb, you're going to be careful when you send certain things.
Boy, I need you to shout that from the rooftops, because what we see on social media sometimes is just mind-boggling that we're actually allowing this to be put out there. I don't think we realize the consequences, whether it's currently, now, or sometime in the future when these things can come back to haunt us. Would you agree with that?
Absolutely. I often joke that I was young and stupid before phones had cameras.
Yeah.
So
Well said. Well said.
I would say absolutely. We don't take enough time to consider the consequences of what we put out into the world before we do it, never assuming that it's going to be us on the receiving end of that later.
Let's wrap this up for folks, Tony. For someone currently going through a divorce in Massachusetts, what advice would you give about how they should handle texting, emailing, and posting online while the case is ongoing?
While the case is ongoing, you generally do not ever talk about the case publicly. Talk about the case with your therapist that I hope that you've gotten, because I tell all of my clients to get a therapist in the beginning of their case. Talk to your friends privately. Don't post on social media. Don't refrain from texting your significant other if at all possible. The reason being is if you get into a fight, I hate text messages in divorce because it's too easy to get angry and just keep going because it's that constant back and forth. I'd rather see people emailing because it takes longer. Text is so instant, and we live in such an instant gratification world today that we feel the need to immediately respond, which prevents people from having the normal reflex to calm down and think about what you're saying before it comes out through your thumbs.
Tony, thank you again for another enlightening and informative conversation. I think you've offered some great tips to our audience today. Folks, that's it for today's episode of Law, Life, and Liberty with Anthony Puopolo. To learn more about attorney Anthony Puopolo and his work across Massachusetts, family and criminal courts, visit agplawoffices.com. Thank you so much for listening. Don't forget to like, leave a review, and share this episode with someone who may need it today. We'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.